In 1863, the Emancipation Proclamation declared 4 million people legally free. But legal freedom and economic freedom were not the same document. Across the American South, freedom without land, without capital, without legal standing in a courtroom, was a narrow thing. What happened in Charleston District, South Carolina, in 1867 was not written into the standard histories. A man who had been the property of a plantation legally purchased the debt-ruined estate, stood in the same courthouse where enslaved people were once appraised like livestock, and walked out holding a deed. Then he married the widow of the man who had owned him. Then he inherited everything. The question this raises is not sentimental, it is procedural. It is about what ownership actually means, who gets to exercise it, and what's the person who does. Now let's return to where it began. The courthouse steps in Charleston District were not swept clean the morning of the debt auction. The posted notice had been nailed to the board outside for 11 days, listing the Alderman plantation, 412 acres, 2 struck mill, against outstanding debts of $9,200. The man who arrived early and stood near the back of the small crowd was named Thomas Alderman. He had taken that surname at emancipation. Before that, he had no legal name at all. Thomas had arrived in Charleston 3 days before the auction. He had stayed at a boarding house on King Street that accepted freedmen, and he had spent 2 of those days in the of a white attorney named Harold Covey, who agreed, for a retainer tumul in paper currency, to verify the debt claim against the Alderman estate was legitimate, that the auction was legally posted, and that a free black man with documented capital could submit a bid. Covey confirmed all 3 points in writing. Thomas kept the letter folded in his coat. He did not remove it from his pocket on the morning of the auction. He simply stood where he could be seen by the auctioneer. Before the auction began, a deputy sheriff named Claude Birch approached Thomas and asked whether he intended to bid. Said that he did. Birch told him that the bidding process required any non-white bidder to have a white citizen co-sign the offer within 48 hours of acceptance. Thomas produced Covey's letter, which cited no such statute, because none existed in South Carolina's 1866 Provisional Civil Code. Birch read the letter slowly, handed it back, and stepped aside without further comment. Thomas Alderman had been born on the Alderman plantation in approximately 1931. There is no earth record. The plantation ledger lists him in 1839 as Tom Coy et Vieters. He had learned carpentry under an enslaved man named Cato, who was sold in 1848. By the time Thomas was in his 20s, he was the plantation's primary carpenter and cooperage worker. He made barrels. He repaired fences. He built 2 of the outbuildings that still stood on the property in 1867. In 1855, the plant's owner, Wallace Alderman, hired Thomas out to a lumber operation in Georgetown County. Thomas was permitted to keep a portion of his wages under a private arrangement with Wallace, not a legal one, since enslaved people had no legal claim to wages. Over 9 years, Thomas accumulated enough to negotiate a manumission agreement. The paperwork completed in October 1864, after South Carolina fell under Union military administration. Thomas was 33 years old. After manumission, Thomas worked as a free carpenter in Georgetown and later in Charleston. He saved. He did not spend on property he did not need. By 1867, Wallace Alderman had died in January 1866 from complications of a wound he received near the end of the war. The plantation had been poorly managed before his death and carried debt that Wallace's widow, Margaret Alderman, could not service. The first notice of foreclosure appeared in March 1867. Thomas read it in a newspaper. Thomas won the bid at $9,400. There were two other bidders. One was a land speculator from Ohio. The other was a local cotton factor named Emmett Greer, who had held a lion on part of the property. Greer bid aggressively early but stopped at $9,100. The Ohio speculator dropped out at $8,600. Thomas held his final number and the auctioneer confirmed it. Covey was present and signed the transfer paperwork. The deed was filed with the Charleston district clerk the same afternoon. The county clerk, a man named Rowan, asked Tommy times during the filing whether the property was being purchased on behalf of another party. Thomas said each time that it was not. Rowan processed the filing. Thomas left with a certified copy of the deed. The news of the transaction, Margaret Alderman at the plantation house within 2 days. A freedwoman named Hattie, who had remained on the property as a hired domestic worker after emancipation, later told a Freedmen's Bureau agent that Margaret received the news sitting at the kitchen table and did not speak for some time. Margaret had known Thomas her entire adult life. She had married into the Alderman household in 1849, when Thomas was already a working carpenter on the property. He had built the shelving in the room where she received the news. Margaret had limited options. The plantation house was on the deed. She had a grown son, Wallace Jr., who had relocated to Georgia after the war and written to her only twice. She had a daughter, Clara, 19, still living with her. She had no liquid assets. Her husband's debt had consumed the estate. When Thomas sent a letter through Covey's office asking whether she wished to discuss the terms of her continued residency on the property, she agreed to meet. The meeting took place at the plantation 1867. Thomas arrived with Covey. Margaret was alone. The conversation was documented only by a brief note in Covey's file, which described the exchange as civil and businesslike. No specific terms were recorded in that document. What changed the situation was not the meeting itself, but a Freedmen's Bureau assessment conducted in 1867. A bureau agent, Charles Firth, visited the property as part of a routine survey of land transfers in the district. His report noted that the deed was valid, the transfer was legal, and that Margaret Alderman was currently residing in the main house without a formal lease or residency agreement. The Bureau report also noted, without editorial comment, that Thomas Alderman had made 2 structural repairs since acquisition: the fence on the north boundary and the mill wheel mechanism. These repairs established his active use of the land. After Firth's report, the practical reality of Margaret's position became fixed in a way it had not been before. She was a resident without a lease, on property of a man who was actively maintaining it. Greer, the cotton factor who had lost the bid, visited Margaret in June. He suggested she contest the sale on the grounds that the posted notice period had been improperly observed. Margaret consulted a local attorney, not Covey, who told her, after a review of the filing dates, that the notice had been correctly posted and that no legal challenge would succeed. Clara, Margaret's daughter, had begun speaking with Thomas directly during this period. The record does not explain how or when this started. What is documented is that Thomas, in July 1867, submitted a formal lease offer to Margaret through Covey's office, offering her and Clara continued residency in the main house in exchange for a nominal rent of $12 per quarter. The offer included a clause. It was valid for 90 days. After 90 days, if unsigned, Thomas would proceed with other arrangements for the property. Margaret signed the lease in August. She did not contest any clause. This is the first legal document that placed Margaret Alderman's name beneath Thomas Alderman's as a subordinate party. In September 1867, Emmett Greer filed a complaint with the district court alleging that Tom Alderman had obtained the property through fraudulent financial representation, specifically that his documented capital had not been legitimately earned, but had been gathered through improper wartime dealings with Union soldiers. The allegation was not supported by any evidence submitted with the complaint. Greer named Harold Covey as a party to the alleged fraud. The complaint required a response. Thomas hired a second attorney, a free black man from Columbia named James Hopper, who had been trained in law before the war under an unusual apprenticeship arrangement. Hopper reviewed the complaint and characterized it in a letter to Thomas and as an attempt to use the court's intake process as a pressure mechanism, without the intention or the evidence to prosecute. He advised Thomas to respond formally, document all sources of his capital, and continue using the property visibly and continuously. Thomas did all three. He submitted to the court a detailed accounting of his earnings from 1864 to 1867, carpentry wages from named employers, contract payments, and the terms of his original manumission arrangement with the late Wallace Alderman, which included a wage-sharing agreement that Thomas had preserved in writing. The document was 11 pages. Hopper filed it in October. Meanwhile, Greer's complaint had consequences on the ground. Several white landowners in the district to sell Thomas the additional lumber he had contracted to purchase for repairs to the mill structure. 2 freedmen who had agreed to work on the property for wages withdrew after what one of them, a man named Joseph Price, later described to a freedman's officer as being told it wasn't safe to be seen working there. Thomas continued the mill repairs himself and with one remaining hired worker. He also made a decision in October 1967 that was not reversible. He proposed marriage to Margaret Alderman. The proposal was not impulsive. Thomas had been in regular contact with the household since the lease signing. He and Margaret had spoken directly on several occasions about the condition of the property, the mill, the north fields, a drainage problem near the western fence line. Whether these conversations had produced anything resembling personal regard is not documented. What is documented is that Thomas made the proposal formally, again through Covey's office, and that the letter was explicit. He proposed legal marriage, which would consolidate this legally and provide Margaret with the security of a legal household rather than a lease arrangement. The moral weight of this proposal was recognized immediately by everyone involved. Margaret was a white Southern widow to legally marry a man who had been enslaved on the property her husband had owned. Thomas was proposing to marry the widow of the man who had owned him. In South Carolina in 1867, interracial marriage was not illegal under the provisional government. It had become illegal again under state law in 1879. Clara left the property within 1 week of the proposal becoming known. She relocated to her brother in Georgia. She sent no further communication to her mother for 2 years. Margaret had accepted the proposal in November 1867. The marriage recorded in the Charleston District Civil Registry on December 3, 1867. Covey and Hopper were both present as witnesses. The ceremony was conducted by a Methodist minister, who later declined to discuss it with a local newspaper reporter seeking comment. The court complaint was dismissed in January 1868 for failure to produce supporting evidence. The dismissal was recorded in the district court register without additional notation. The event that forced the central conflict into a public and irresolvable form occurred in March 1868. A group of 7 white men, some of them former neighbors of the Alderman property, arrived at the plantation on a Saturday morning. 4 of them were armed. They were not affiliated with any official body. their stated purpose, as later described in a Freedmen's Bureau incident report, was to inform Thomas that his continued occupation of the property was not going to be tolerated. Thomas was working at the mill when they arrived. Hopper had advised him, months earlier, that such a visit was possible and had outlined a specific protocol. Do not engage physically, do not leave the property. Send immediately for the nearest bureau agent or Union garrison. Thomas followed this protocol. He went into the main house, where Margaret was present, and he sent their remaining hired worker. Joseph Price had returned by this point, on horseback to the bureau station 4 miles away. The men remained on the property for approximately 2 hours. They entered the main yard. 2 of them walked to the mill and examined it. One of them spoke to Margaret directly through the window of the main house and asked her whether she was there by choice. She answered that she was. He asked if she understood what she had done. She said that she did. The man said nothing further to her. When the bureau agent, a captain named Ellison Drake, arrived with 2 soldiers, the men on the property had not committed any documentable act of physical violence or property destruction. Drake recorded their names. 3 of them gave false names and issued a formal warning that armed trespass on private property was subject to prosecution under military administration. The men left. Drake's report to the bureau office described the incident as intimidation without actionable offense, consistent with pattern harassment documented in surrounding districts. He recommended increased monitoring of the alderman property. No increase in monitoring was documented in subsequent bureau records. Thomas, after the men left, went back to the mill and continued working. This is not inference. Price later told the bureau that he watched to return to the mill work within 30 minutes of the group's departure. Price described this as the most deliberate thing he had ever seen a man do. In April 1868, Margaret drafted a will. It named Thomas as sole beneficiary of all personal property she held claim to, including furniture, household goods, and her late husband's personal documents. Since the plantation deed was already in Thomas's name, the will's practical effect was limited. But it was a legal document that placed Margaret's intent in the public record. Covey, original copy. A second copy was filed with the district clerk. Wallace Jr. wrote from Georgia in May. The letter, Margaret preserved and which later passed into a Freedmen's Bureau collection, was direct. He said that what his mother had done had ended her relationship with the family, that he would not be visiting, and that he expected no inheritance. Margaret wrote back a single paragraph acknowledging the letter. She did not ask him to change his position. By the summer of 1868, the alderman plantation was producing again. Thomas had brought 2 acres of the east field back into cultivation with workers, all of them freedmen. The mill was operational. The property was no longer in debt. These facts were recorded in a Freedmen's Bureau Agricultural Survey dated August 1868. Margaret Alderman died in February 1872. The cause recorded in the county register was pneumonia. She was 51 years old. Thomas was present. There were no family members at the burial. A Freedmen's Bureau agent, who had monitored the plantation since 1967 as an observer, and recorded the event in a final case note. Thomas continued to operate the plantation for 11 more years. He sold the western acreage in 1874 and used the capital to expand the mill operation. By 1879, he employed 14 people, 12 of them freedmen, 2 of them white day laborers. The property was listed in an 1880 agricultural census as productive and debt-free, owned by T. Alderman, race listed as colored. In 1879, South Carolina reinstated the prohibition on interracial marriage. The The law did not retroactively void and Margaret's marriage, which had occurred under a different legal framework, but it signaled the direction of Reconstruction's collapse in the state. The bureau that had monitored the property had been officially dissolved in 1872. Thomas had no institutional protection after that point. Joseph Price remained on the property and worked for Thomas until 1881. In a brief oral testimony collected by a historian in the 1920s, Price said that Thomas never spoke about what had happened in the courthouse or in the marriage or in the years of harassment. He said Thomas about the mill, about the fence lines, about what the soil needed. Price described him as a man who had decided that the work was the argument, and that making the argument out loud would give other people the opportunity to answer it. Clara Alderman returned to South Carolina in 1876. She did not contact Thomas or visit the property. She died in Charleston in 1901. Wallace Jr. remained in Georgia. He died in 1908. Neither sibling contested the estate or filed any legal challenge after Margaret's death. What the official record shows: a legal sale, a legal marriage, a legal inheritance, a functioning agricultural property. What the official record does not show: the names of the 7 men who arrived armed in March 1868. What happened in the conversations between Thomas and Margaret that were never documented? Whether either of them understood what they had entered, or whether understanding it was beside the point. Thomas Alderman sold the plantation in 1883 and relocated north. The buyer was a white land company from Columbia. The sale price was fair market value. The deed transfer was routine. No record explains why he sold, or where he went afterward, or whether he chose to leave or was pressured to do so. The plantation continued to operate under the new ownership. The mill he built and repaired remained functional for another 20 years. His name does not appear in the property records at 1883. What he did with the rest of his life is not recorded anywhere that survives.